Mr. Sims.
Subject to anything else that you may wish to ask of our appeal, those are our submissions.
On the appeal.
And the rest, I think I said before, but will rest on our written case, unless there's anything further required.
Just check. No, thank you very much. Mr. Ayres.
My lord, my ladies, this is an egregious case. And the reason why it's an egregious case is that it's not your run-of-the-mill breach of warranty claim. Not only were lies told to the claimant as part of the sale process, but GDE, through at least James Norvill and Lindsay Kelly, were lying to the regulators about compliance of the Wet Waste Division for some time. I want to begin, if I may, with some small preliminary points just to make sure that your lordships and your ladyship have them. First of all, the purchase price. Just to be clear about that, that is correctly stated in paragraph 128 of the judgment. The purchase price, which is agreed for the purposes of this appeal, is £3,584,224. There was an issue at trial, which doesn't need to trouble us anymore, about an additional element, which was in fact paid by the purchaser as part of capitalisation, and that's obviously accepted or was accepted at judgment not to be part of the purchase price. So that's the figure for the purchase price.
And that was £3,584,224. Thank you.
It's at the bottom line on page 92 of tab 5. But the other thing that's relevant, or may be relevant, in the factual matrix of this particular case is if you go over the page, the valuation of the shares at effectively £3.5 million was not arrived at by a method agreed between the parties, but it appears that the approach adopted by or on behalf of MDW. Because of course you have some breach of warranty claims where in coming to the price, the parties have actually communicated about their valuation method and it's crossed the line. So that then to some degree informs the valuation issues going forward in the case. That's not this case. There was no communication between the parties. The parties arrived at the purchase price in a situation where they were not communicating about the valuation methodology. The next small point, just to, my learned friend mentioned it, leachate. Before I came to this case, I didn't know what leachate was, and it's correctly but very shortly described in the judgment at paragraph 11 as the runoff from landfill sites. But just to give it a little bit more colour, I didn't realise that in relation to landfill sites, you don't just throw the rubbish in, they actually tank it at the bottom so that it's a sealed container, so that actually you're not getting contaminants into the land. And of course, if it's tanked, as we know from the bottom of our kitchen bin, sometimes liquid develops, unpleasant liquid, and the unpleasant liquid is what this leachate is, highly rich in ammonia and very unpleasant, and something that needs to be dealt with.
As it happens, I learned quite a lot about this last year in a tax case called Devon Waste Management, I think, which was all about landfill tax.
Well, your lordship's probably ahead of me. I have to say I've never visited a landfill site, but maybe I'll get the pleasure one day. The next preliminary point, and it is a point of some significance, is that there's no dispute now, and there's never been a dispute in this case about the date of assessment. And this is important, because when we're looking at this question of contractual damages, and I hope tortious damages as well, we're not in a freewheeling world of categories. We are certainly in the world of contract. We are starting, and we'll come and look at what Mr. Justice Popple says about this, we're starting from the breach date rule. And the reason why I'm emphasising this at the beginning is that there are enormous academic and intellectual questions about whether the breach date rule exists. And the thankful thing is that your ladyships, your lordship, are not going to have to grapple with that, because we are agreed that the date of assessment, whether it's for a contract or tort, is the 14th of October 2015. The core point on the appeal is about what has been described as the impact of potential future reputational damage on the valuation of the shares of a private limited company as at the 14th of October 2015. I'm going to come back to the authorities in due course and to what I say is the relevant point of law. But to summarise what my core submission now is about the point of law, in contractual damages, contingencies can be taken into account for the reasons set out by Mr. Justice Popple in the Aegeus case, subject to his riders, which were necessary to give effect to the overriding compensatory principle, and secondly, the contractual allocation of risk point in an appropriate case. And we'll come and look at it in due course, but in the Aegeus case, Mr. Justice Popple uses the phrase "in an appropriate case" twice when describing the test. And if your Lordship and your Ladyships are going to be zeroing in on any specific point of law and deciding to decide it, what is an appropriate case is the core and perhaps slightly difficult question about this case. The structure of my submissions are as follows. I want to first of all, if I may, and I'll do it fairly smartly, but it is necessary, take you through some of the parts of the judgment which I say are relevant. Secondly, I'm going to deal with the contractual questions. Thirdly, I'm going to deal with the tortious question of arguability, which has been raised, which I do need to deal with, and about which our latest note deals. And then finally, I'm going to deal with some wrap-up points and some other responses. So first of all, looking at the judgment, if we may, it's a reasonably long judgment, and it covers a large number of matters, some of which aren't relevant for the purposes of the appeal. But if we can please just go through some of the key elements. My learned friend took you to page 48, that's got the index on it, and there are a number of different parts of the judgment I want to take you to. I'll point out for later purposes specifically section I, which is the judge's decisions about liability for misrepresentation. And then if we can turn to page 52, that's the start, although the heading's on the previous page, that's the start of the section about the regulatory framework. And the very first sentence in paragraph 17 that the judge puts there is the management and disposal of waste is highly regulated, and the operation of a waste management business such as GDEs is dependent on consents and permits from environmental regulators. And if we go through to, if you look at paragraph 19, that describes what's called the permit, and it's got a number. It was granted by the Environment Agency, and that's the body from which Natural Resources Wales took over its responsibilities. So references to the EA and the NRW are interchangeable, and that's one of the key documents under which GD operated. And then if we go on to paragraph 24, that deals with the relevant consent, which is described as the 2012 consent. There were previous consents that were afforded to GDE, and in this case the consents are provided by or issued from Welsh Water. So we have this effectively dual regulation system operating with different documents and sometimes overlapping obligations. And then at paragraph 25, the judge sets out some offences, and unsurprisingly there are offences relating to this, both in relation to NRW and Welsh Water, that if, to summarise, one knowingly or recklessly provides false or misleading information to the regulators, then that's a crime. And that's an important part of the context. And then turning on to page 57, we start the narrative section of the judgment. And I'm not going to labour any of this, but I will pick out some points. But right at the beginning of this section, in paragraphs 29 and 30, the judge sets out some facts relating to an email way back in March 2013. And this is an interchange between Miss Kelly and James Norvill. And at the end of paragraph 30...
who is Miss Kelly?
She is the general manager of GDE for the relevant time. She also was the girlfriend of Mr. James Norvill as well, all through the relevant time. And at the end of paragraph 30, the judge concludes in relation to this particular email, which I won't trespass on the details of, in relation to James Norvill's explanation. He says, and this is halfway down paragraph 30, however, it goes further than that because it also expresses an unwillingness to make the regulator aware of non-compliant practices. The evidence as a whole leads me to the conclusion that James was prepared not only to conceal information from the regulators, but to provide them with false information. And then if one turns on to paragraphs 38 to 40, we're now in the beginning of 2014, and there's a reference to email communication between Mr. Gray and Ms. Green. Mr. Gary Gray is the operations manager, or is effectively the key plant operative at the wet waste side of the business. And Miss Green is a reference to Miss Rebecca Green, who is the person at NRW responsible for policing the permit granted by NRW. And again, I'm not going to read it all out, but what this section of the recorded evidence sets out is, at this particular time in 2014, is the scheme which seemed to be operated, certainly as between Miss Kelly and Mr. Gray, whereby if unfavourable numbers were going to be recorded by GDE's own sampling, those numbers would be specifically and deliberately altered for the purposes of passing on to the regulators. Now, it wasn't always the case that the numbers were deliberately falsified to bring them below the actual limit of the permit or the consent, but they were sometimes brought down to within a more acceptable range, and there's one particular example here. And the way in which this was done is that the decimal points were never changed, but effectively the integers were always just reduced by another integer. There was cross-examination about this, and in paragraph 39 it says, when confronted in cross-examination with her email exchange with Mr. Gray, Ms. Kelly accepted that he had provided falsified data to NRW on her instructions, and that her behaviour was disgraceful. And then over the page at the bottom of paragraph 39, the judge comments, this gives the lie to her attempt at trial to portray her behaviour on this occasion as out of character. And then further down at the end of paragraph 40, the sentence starts, however, the email exchange earlier the same month leads to the conclusion that it is probable that either Miss Kelly instructed Mr. Gray as to the specific falsehood to be communicated on this occasion, or she had given him a general instruction and authority as regards what to do with inconvenient figures. And then we now come to James Norvill, and if we can go on to paragraph 45 and following, we have an email of the 19th of February 2014, and what it says in the first main paragraph up from the bottom of page 63, in cross-examination, James denied that he had been encouraging a false explanation and falsification of sample data. He said he would have discussed the matter with Mr. Gray, Miss Kelly, or Mr. Roderick. And Mr. Roderick, just to be clear, he's the person who came in as a general manager for the whole business at some subsequent time, before sending the email, and would have known there was a problem with a pump, though not the precise nature of the problem, and that there had been favourable records to present to Welsh Water. I do not consider that a probable explanation, and I do not accept it. And then the judge goes through 7 reasons why he doesn't accept Mr. James Norvill's explanation as to the email he'd sent. An email in which he'd suggested, you can see it on paragraph 63, can we get a diary entry to read that one of the pumps failed whilst testing hydro, or something along those lines. So that explanation was not accepted by the judge, and at the end of paragraph 45 on page 64, the judge concludes in his 7th reason, seventh point, in the context of the evidence as a whole, I consider that there was a culture of lying to the regulators when it was convenient to do so, and that James, as well as Miss Kelly, was complicit in this. And then if we move on in the narrative, we move to events moving up to the sale process itself, particularly from paragraphs 51 onwards. And if we turn please to paragraph 61, there's a part of the evidence which now relates to GDE sample data which was being provided to a company or an organisation called Gambit. And Gambit were the seller's agents for the purposes of this transaction. And what this paragraph concludes is that as well as falsifying material to the regulators, this sample data, which was highly inconvenient and in breach of consents, for the purposes of preparing for the sale, Miss Kelly and Mr. Gray were involved in the doctoring of the sample test results for the purposes of providing them to prospective purchasers at the sale. At the end of that paragraph he says, however, the sequence of events, the modus operandi and the lack of a plausible alternative explanation justify the conclusion that it was Miss Kelly who falsified the data. In cross-examination she denied any recollection of doing so and also denied that James had instructed her to falsify data. And then paragraph 62 to 65, we're dealing with still in June 2015, so we're getting closer to the transaction. If one looks at paragraph 62 to 65, there's further conclusions by the judge about the provision of false and falsified sample data to Welsh Water, and in particular in paragraphs 64 and 65. And in 66 it says, Miss Cavill's evidence, which I accept, was that she was unaware of the true figures. And Miss Cavill is the person who's the equivalent of Miss Green at Welsh Water. She's the Welsh Water person responsible for the relationship with GDE and policing the consent. And so the transaction takes place in October 2015, and then we get a part of the judgment which relates to events after the acquisition, and that is paragraphs 93 to 120. Now, for a number of different reasons relating to this appeal, my lord, my ladies, this section is incredibly important for the purposes of considering the question of the hindsight question that's being raised by my learned friend. And what this section does is describe, sufficient for the purposes of the judgment, all the action that was taken by the new owners in conjunction with NRW and Welsh Water to get, if I might use a colloquialism, to get the business back on track. So the transaction happens 14th of October 2015, and if one then turns over the page 79, and looks at paragraphs 95 and 96, what of course is happening is that throughout this period of time, both before and after the purchase, Welsh Water is writing to, and this is all recorded in the judgment, is writing to GDE saying you're in breach of your limits under the consent, because of course GDE, although it was actually committed to hoodwinking regulators, it couldn't hoodwink them completely, and the reason for that is because there was effectively a dual testing regime. GDE did its own sampling, lied about the test results to the regulators, but of course the regulators themselves would come and do their own sampling, and of course when the regulators did it themselves they would show readings which were in excess of the limits. So Welsh Water was aware that there was effectively ongoing and persistent breaches of the consents. But intrinsic, of course, to the breach of warranty and deceit claim was the fact that other than one document, none of that communication and correspondence was ever passed to my client as the prospective purchaser. That goes to the questions of liability. Well, we have a seminal moment that comes at paragraph 96, which is, and we don't have a copy of it in the bundle, but which is the letter of the 11th of November 2015, which was a very big moment in the chronology, which is when, rather than just emailing saying you're in breach of limits, we really need to do something about it, Welsh Water wrote a formal letter to GDE giving not just a sort of you are at risk of prosecution, but giving notice of intended prosecution. And that is the letter that really sent the alarm bells ringing. So at paragraph 98, we've got reference now to Mr. Linus. Mr. Linus is the Australian gentleman who was brought in by the new owners to be the new general manager. And he, in paragraph 98, on the very day after the receipt of this notice of intended prosecution, he indicates that the leachate production or leachate processing would be suspended. And then in paragraph 101, at the end, 20th of November, we've got actually GDE stopping taking leachate at all. Paragraph 102 is where GDE instructs this new environmental scientist, Mr. Ellison, who my learned friend referred to, albeit not by name. And then in paragraph 103, in December 2015, GDE recommenced processing of leachate. But that wasn't the end of the story. There's continual collaboration and working with both NRW and Welsh Water. And I'll come to it in a minute, but if we go on to page 84, paragraph 111, although there's some query about the facts, we then have another period of non-operation for the leachate set out in paragraph 111 from around April 2016 until mid-June 2016. So again, these are all the, I don't need to labour it, but these are the actions of responsible owners who are keen not to breach their consent, so if needs be, you actually shut down production for significant periods of time. There's one paragraph I do want to draw your attention to in relation to the history of misconduct. That's paragraph 109, and the judge says in his witness statement, Oliver Hazel, who was one of the MDW owners, commented that NRW were probably unaware that the breaches that took place prior to October 2015 were deliberate breaches occurring with the full knowledge of the then owners and management. And the judge says, I do not think that a witness statement is the appropriate place for a comment of that sort. And that's what he says, but then he adds, however, as it happens, I agree with it. And then if we go down to 113, it says, Mr. Linus came to the conclusion that the only way in which the leachate treatment process could operate profitably was to have a continual flow to the drain, but the only way in which he could operate lawfully was to process leachate in batches and not continuously. So there's just a huge problem.
Sorry, that was paragraph
113. And I'm not going to go through all of this, but this whole section, 93 to 120, very important. But it ends in 120 in October 2017 with, and the reasons aren't set out in the judgment or concluded by the judge, but the leachate contract with Newport City Council it fell due for renewal in that period of time, but GDE did not secure renewal of the contract and never went ahead with option 3 of its improvement works, which it might have done pursuant to Mr. Ellison's recommendations. So, as I said, open and honest actions of new owners. GDE in this period of time sought to turn the position around, and it's not in dispute that there was no actual prosecution. It's not in dispute that the permits and consents were retained, albeit that they were retained in close cooperation and open and honest communication with NRW and Welsh Water. I'll come back to this obviously when we come to the nub of the issue in the appeal, but what the defendants want to do is that they want to select what is effectively a narrow conclusion, no suspension or withdrawal of permits leading to no financial ramifications, to say that it's unfair to value the shares as at the 14th of October as seriously impaired by the disgraceful actions of the sellers pre-acquisition, and obviously we take issue with that. So we're still in the judgment. I'll come back to the expert evidence section in a minute. We've got a few more passages to point out to you. There's some more malpractice which is set out in relation to tank bottom waste. Now, tank bottom waste, not something that's a big feature of this appeal, but the judge said it didn't sound in any damages. So, and we're not appealing that point, but it did establish a breach of warranty though, and it did so because there was misconduct by the previous owners of GDE, and one can see that if we can turn please to paragraph 174.
Can I just be clear? The judge doesn't take this into account, does he, in calculating the reduction of the multiplier?
No, he doesn't.
In which case, does it actually help us?
It doesn't, but it doesn't help you in relation to the question of quantum at all, but it's part of the picture of misconduct which goes to the question of what a reasonable purchaser on evaluation would consider.
Well, save that if the judge has concluded that the reasonable purchaser will make a reduction because of the leachate matter and hasn't concluded that there will be any reduction in relation to this matter, does it go anywhere?
Well, probably not, no. It's just another example of the improper practice. I'll just give you the paragraph references without going any further, 174 and 192. And then leaving the facts to one side, we then have paragraph 106 onwards, which is the pleaded case. And again, I'll come back to this later on, but it's absolutely clear the pleaded case is breach of warranty and misrepresentation. Both written representations, oral representations, implied representations. And then if you look at paragraph 208, it's very clear the judge is reciting that he's considering a fraudulent misrepresentation claim as well as a common law negligence misrepresentation and misrepresentation under section 2 of the 1967 Act. So that's what he thinks he's dealing with. And then if one goes on to section I, which is on page 141, the judge deals with liability for misrepresentation. He goes through the written and oral representations. He goes through fraud and negligence, and his key conclusions are in paragraphs 259 to 262. And in 260 he said, I find that James knew that the written representations were being made. It's not been suggested that he did not know. I also find that James knew that the representations in respect to breaches and Welsh Water's sampling results were false. There is, in my view, no doubt that he knew of the persistent breaches of the 2012 consent. In his oral evidence, he claimed that between May and October 2015 he was being assured that the discharges were within permitted levels, but I reject that evidence, which is incredible and receives no objective support from other evidence. Consideration of the totality of the evidence, including in particular specific points mentioned in the foregoing narrative, persuades me that James knew perfectly well of the matters of non-compliance at all times before the SPA. And then 262 says further, none of the defendants had reasonable grounds for supposing the answers in respect to the breaches and sampling results to be true. Indeed, Jane and Stephen, who are the parents, had left the negotiation and handling of the sale to James, and they're responsible for his fraud, although themselves innocent of it. And then in 274 onwards, the judge deals with reliance. And I wonder if I may just to come back to the expert evidence section, which is section D, and go back to paragraph 127. That's the expert evidence section, and that's where the judge goes through that. But importantly, for the purposes of this appeal, can I take you to paragraph 139, which is the judge's assessment of Mr. Mesher's views on valuation, and I'll come to look at Mr. Mesher's underlying documents in due course. But subparagraph 1 that says on 1391, on a warranty true basis, the natural assumption is that GDE was worth what MDW as a willing buyer at arm's length paid for it. And then 2, he then goes through Mr. Mesher's analysis, but the final sentence, and I'll take you to the underlying document in due course, the assumption that MDW paid the true value of GDE is therefore confirmed on a warranty true basis. And then at subparagraph 6, the judge recites Mr. Mesher's views as follows. Mr. Mesher accepted in principle that a history of persistent regulatory breaches could possibly result in some reputational damage and thus have some impact on valuation, but he did not consider Mr. Gates's somewhat arbitrary application of a 25% discount of the multiplier to be justified, and he made no allowance in that regard. So, my lord, my ladies, that is all I wanted to say in relation to the judgment and the relevant facts. Obviously, that part of the judgment 93 onwards, as I said before, is very important. I want, if I may now, to turn to the question of the contractual measure of damages and this point of principle or arguable point of principle in relation to hindsight. And so, as we've seen already from Malone and Friends submissions, the judge deals with this at paragraphs 288 and following, and he rejects, it has to be accepted in fairly short terms, at the end of paragraph 288, he rejects the submission made by the defendants at trial that there should be no discount to the multiplier. Now, I'm going to come to the case law in a minute, but in essence I've got three core reasons why the appeal should be dismissed on this ground. The first reason is that, consistent with the breach date rule, a starting point is to consider events up to the date of assessment. If there is to be an event which is said to be a relevant contingency affecting the calculation of loss, the burden is on the defendants to establish that, and in my submission they haven't discharged that burden by showing that it's necessary or appropriate. That's the first reason. The second reason relates to this question of the overriding compensatory principle. Now, my learned friend's taken you to quite a number of examples in the cases of where the overriding compensatory principle is set out. But it's not really very easy to extract very much more when you read those, because it's really the statement of the obvious. You get compensation, you don't get more, and you don't get less. The question really, when we come to look at the Aegeus case, is have you identified a windfall? That's really the question that Mr. Justice Popplewell wants to pose. And in my submission, there's no question of a windfall in this case when you look at the material that the post-breach events set out in 93 to 120 of the judgment. And in relation to this question of windfall and overriding compensatory principle, I've got really two subsidiary points, and to some degree they may well be the same point. But two subsidiary points are, first of all, actual damage as at the 14th of October 2015. And the second point, which is maybe the same point, is valuation. Willing buyer and willing seller as at that date. So, actual damage. So my submission is that there was actual damage to the shares by reason of all the regulatory non-compliance problems that the business suffered. As at the 14th of October 2015. Again, I don't want to labour it. It's not a unique type of business, but it's an interesting type of business. It depends for its very existence on consents and permits. And obviously, in the real world, you realise that the regulators don't lightly want to remove these consents and permits, because if they completely wash away someone's ability to do this, then you might leave a whole community without proper waste management. But the reality is, it's not something which is completely off the cards or off the table. You've got to have these consents and permits in order to do business. And in terms of the actual damage, if you have a situation where a business is consistently lying to the authorities in order to keep the business or part of the business going, then that is something which plainly is going to do actual damage to the value of the shares.
So no contingency of any kind. I'm so sorry.
No, sorry. Yes,
Who
no, I
wants
was
to
just
go
coughing.
first?
I was just spluttering over my laptop.
Oh, okay.
Sorry.
So no contingency of any kind, actual damage at the date of the SBO.
Yes, well, either your ladyship or your lordship, your ladyship has passed through McConnell and Wright, and we'll come and have a look at that in due course and what one can extract from that. But I'll come and develop my submissions about Aegeus in a minute. And I heard my learned friend who's criticising Aegeus, or certain elements of it. That's news to me. I'm not going to say, for these present purposes, that it's wrongly decided. I'm going to reserve my position about that. But I do accept that in principle, providing you can come within the Aegeus test, that you could have a contingency in relation to a warranted claim in relation to the valuation of shares. I mean, that is what Aegeus is saying.
But you're saying this is not contingency. This was something which was inherent
Yes.
at the time.
Yeah.
I mean, when you say you're not going to say that the GS is wrongly decided, the result in the GS you like, therefore you're certainly not going to disavow that, are you?
Well, I'm not, but I mean, that's helpful for me in the same way that the Hutt Group is somewhat helpful to me, is that there isn't an example yet of, in relation to a share purchase agreement, a breach of warranty claim, of a successful contingency argument being run. And what does one conclude from that? You can either conclude that it's very, very difficult to run contingency arguments in relation to the valuation of share, or the other conclusion, which I'm going to keep heavily reserved, is that the GS is wrong, and you just simply can't have any contingencies in relation to the contractual measure of damages, because you are valuing the shares as at the date. And if you're doing that exercise, then it's just absurd to look at contingencies. Because, of course, when I come and make our submissions about contingencies in a moment, and the problem with contingencies is how do you isolate the contingency? And where do you stop? And that's really the problem with this appeal. Your ladyship's right, it's actual damage at that particular point, it's a valuation exercise. And that's why it is important to focus on what the exercise is. In my submission, it's an exercise of valuation of shares. It's also, of course, it will be said that this is a valuation, this is a loss valuation. But there are conceptual differences between valuation of income streams for the purposes of damages on the one hand, and the valuation of assets. But I can't press that submission too strongly, because Mr. Justice Popplewell and other cases have not disavowed that case. This Justice Popplewell says you can have this sort of contingency argument, you can have the golden victory coming into share sale valuation, which...
Since I'm sure we're getting on tomorrow, can I just drop in another case I saw reference to over lunch, and which I haven't attempted to think through the implications of, and that's a decision of the Court of Appeal in 2019, a case called possibly Compass, but the leading judgment was given by Lord Justice Males, and at least in that context, which was all about charter parties, I think, or contracts with freightment, the Court of Appeal was treating the golden victory and bunga or bunga, or however you pronounce it, as tied to anticipatory breach rather than actual breach. And it may be that's something that it would be worth thinking about overnight in case there's anything to be got from it.
Well, the difficulty with this area of law is that there are all these little micro rules that seem to operate and relent us, and also you're trying to get some general principles in relation to the measure of damages. But if you look at the golden victory, and if you look at, I'm reliably informed it's bunga. Bunga, I think it's bungi, not bungi.
Bungi, is it?
Bungi. They're both cases of repudiatory anticipatory breach, both of them. And obviously bungi extends the matter to all types of contract. But yes, my lord, I'll have a look at that. But well, just coming back to your point about valuation as at the point in time, if you're valuing the shares as at a particular point in time, and you have what I would hopefully not tendentiously describe as a business with the potential for criminality that this business had prior to the date of acquisition, it's remarkable to think that there would not be at least a small downwards adjustment to the multiplier in terms of valuation. And that really links into my second point, which is probably the same point, which is about willing buyer and willing seller. I'll give you the reference, but that valuation, that well-known valuation test, is not in issue, and it's in Mr. Mesher's own report. That's supplemental bundle, tab 4, page 76, paragraph 2.10.
Could you just give the reference again? Sorry,
yes, supplemental, tab 4, page 76, paragraph 2.10. And that's, Mr. Mesher agrees that it's valuation involving a willing buyer and willing seller, an arm's length transaction, proper marketing, and a knowledgeable, prudent party is not acting under compulsion. That's what he says. There's nothing controversial about that. And it's dangerous to get into analogies. The horse is all over the place in this area of the law. I'm going to steer clear of the horse, but maybe a better analogy is like a cracked vase. This is, would you pay the same for a cracked vase as you would for the perfect vase? And maybe that's an OTO's analogy, but that's the analogy that I want to promote. And that's what was going on here. It was a cracked vase, which the purchaser then did a lot of hard work to get in good shape. So a knowledgeable and prudent purchaser with knowledge of lying to the regulators and the possibility of crimes being committed. And one has to remember that the crimes fall into two categories. The crimes fall, there's the being in breach of the permits, which are potential crimes. And then there's also the lying to the regulators, which are potential crimes. So we've got those two different categories. Any reasonable purchaser in that category would run a mile from this transaction. If they didn't run a mile, they would, in my submission, require a significant reduction.
Just taking you out of course one moment. Is there any finding as to which you would have been? Would you have gone ahead, if you had known the truth, would you have gone ahead with the transaction at a reduced price? Would you have withdrawn from the transaction, or is that something as to which there is no answer?
There's no judicial finding in relation to that. But there is an implicit finding in the sense that because the fraudulent misrepresentation claim was made out, it's implicit in that the transaction would not have gone ahead.
When you say not gone ahead at this price, yeah, or not gone ahead at all?
Well, I can't help your lordship in relation to that. But I'll check the judgment to try and answer that question. So that's the second reason, which is this isn't a windfall situation. The third reason relates to this question of contingency. What sort of contingency are we looking at? And my submission about the appellant's case is that the contingency they're putting forward for these purposes nebulous, vague, and insufficiently connected to the transaction and transaction date. So the first thing is it's unlike the Golden Victory and Bungie. It's a non-event we're looking at. So the non-eventuation of the removal or suspension of permits or consents, the non-eventuation of criminal prosecution. So if it's a non-event, when's it to be measured? Is it to be measured at the date of trial or at some other date? And there's some inherent uncertainty about that. And the biggest difficulty in relation to this contingency, in relation to looking at it on the Aegeus standard, is that you're simply not comparing like with like. So we have the transaction date, and then let's say we're going to say that the start of trial, which is January 2021, that's the date when we are going to say, well, there was no prosecution of no revocation of or suspension of licenses. You're dealing with two very different businesses. And the reason I can say that is because of looking at at least paragraphs 93 to 120, and you look at the enormous number of things that the owners did to put things right with the regulators, and behaved in a marked contrast to the defendants when they were owners. And those actions included dealing with regulator interventions, internal investigations, remedial work, and voluntary shutdowns. It's, in my submission, it's simply just a non sequitur to say that because, for example, in January 2021, GDE was still in business, it's somehow unfair to reflect the fragility of the goodwill in October 2015. I think as my Lord or Justice Newey said, we're not dealing with a binary world in which everything's great or everything's a disaster. There could be all sorts of shades in between. And we'll come and look at Aegeus in due course, but one of the things that did for the contingency argument in Aegeus was this idea of multiple variables, which mean that you're not comparing like with like. And in my submission, all the things that took place, all the things that my clients did post-purchase were effectively multiple confounding variables. And it's simply impossible to say that the absence of the suspension and revocation of consents means that the regulatory compliance of the pre-acquisition company should not be factored into the value as at sale. And I just touch on something my learned friend talked about. He used the word causation. And again, without wanting to be too strict about things, we've got to be very careful about how these words are being used, because it's not an issue between the parties that the date of assessment is the 14th of October 2015. So in terms of causation, the pure contractual questions of causation run up only until that date. So when perhaps he's using the word causation, he is actually inviting consideration of this question of what is the cause of the company not in fact being in a parlour state. And really that makes my point for me, which is that is it right that in terms of all the efforts that my clients went to make sure that the company was in a good state, that means that somehow the defendants, even on a contractual basis, should get the value for that. But coming to the cases, I want to focus on Aegeus, but before I do that, in terms of the Bulfer principle, who can quibble with the Bulfer principle, which is, why guess when you know? Nobody can quibble with that, but the point is, know what, and what question are you answering? I mean, that's the core of it. So nobody can have issue with the Bulfer principle. Similarly, in terms of the majority decision in the Golden Victory, it's eminently understandable. You have a situation where there's an anticipatory repudiatory breach in respect of a charter party which has got 4 years to run, and in circumstances where it's known that the Second Gulf War would break out to bring that period of time to an end, and that's known by the time of trial, you might say it's absolutely obvious that that should come into play for the purposes of curtailing the extent of the loss that was claimed. But, my lord, my ladies, if we can concentrate on Aegeus, and that's in tab 10 of the authorities bundle. And as I said before, I'll say it formally again, subject to some twists. I'm not saying Aegeus is wrongly decided. I want to reserve that in case this case goes to a different appellate level. But really the heart of, or perhaps one decision your Lordship, your Ladyship is going to make is whether you are going to endorse Aegeus, because it's been covered by a number of different cases, but it hasn't had the full thumbs up yet from this court. It's a first instance decision. It relates to the treatment of an accounting item, time on cover bad debt. Insofar as it's relevant, if you look at paragraph 9, the valuation methodology for this particular case was a discounted cash flow valuation. And the reason I mention that is because, for a point I'll come to in due course, which is that these cases, there are different valuation methodologies which are perfectly legitimate. But these cases are, to a large degree, if not wholly, being decided on expert evidence. And providing the expert evidence is sufficiently driving the conclusions, then this court should be very cautious before interfering. And then my learned friend's taking you some of this. He's taking you to paragraph 14, which is an uncontroversial expression of the test. And you'll see at the end of paragraph 14, there's a statement which we say also applies in this case. We'll come back to it. It was common ground that the value of the shares as warranted was the price which Aegeus paid, namely £214 million, which was very close to the figure produced by the DCF model using Aegeus's assumptions and key performance indicators. So that was the warranty true value. And then we've got Mr. Mesher referred to. He's involved, as you've heard. And then in paragraph 31, we have the submissions of counsel for AIG, Ms Robertson, in relation to the Golden Victory, and she's seeking to pray in aid, and the Bulfer principle as well, if one then goes over the page, certainly to paragraph 33. And then the first part of, or at least what might be the ratio of this case, is in paragraph 34. It says, whilst one way of giving effect to the compensatory principle is to take a date for assessment of damages which is later than the breach, that's not our case, there is no conceptual difficulty in using subsequent events to inform an assessment of value at an earlier date in an appropriate case. That's where he uses that phrase for the first time. And then he refers to Phillips and Brew and Dolphin, which my learned friend's taken you to.
Which strictly, of course, is not a damages case, it's a transactions and undervalued case.
Yes. Indeed. And then, if we then go through on to paragraph 35, Mr. Justice Popwell says, the Bulfer principle, as applied in the Golden Victory, supports the proposition that when assessing damages for breach of contract by reference to the value of a company or other property at the date of breach, whose value depends upon a future contingency, account can be taken of what is subsequently known about the outcome of the contingency as a result of events subsequent to the valuation date, where that is necessary in order to give effect to the compensatory principle. In an appropriate case, the valuation can be made with benefit of hindsight, taking account of what is known of the outcome of the contingency at the time that the assessment falls to be made by the court. And this isn't really a cross-checking exercise. Then in 36, he deals with the racehorse. And then in 37, he puts his note of caution down with his two qualifications. The first qualification is necessary to give effect to the overriding compensatory principle, or with absolute respect to Mr. Justice Popplewell, that you might say that's begging the question, or simply just reposing the question. But then he then...
But you like the further sentence there?
The further sentence is important, because that's setting the general rule, which is the prima facie rule, from which departure must be justified. And that's why I come back to my first point, which is that it's up to the defendants to justify, is that damages are to be assessed at the date of breach, and that only events which have occurred at that date can be taken into account. And then the second qualification relates to the allocation of risk. Now, I'm not going to be making any submissions about allocation of risk in this particular case. So I was rather surprised to hear my learned friend wishing to criticise that. But as far as the legal principles are concerned, I would submit that allocation of risk is absolutely important as part of this process. If there is a contractual allocation of risk in relation to a particular future contingency, why should that not determine the question as to whether or not it's to be taken into account?
Is it wholly irrelevant to this case? I mean, it might be said, well, look, when you took on this company, you were taking on the risk of disaster, the chance of no problems arising. You were paying because you were taking the risk either way.
This is an ordinary warranty claim. So there's a division of risk. So there's a risk taken by the purchaser because you're getting the asset and taking it, and taking the risks concomitant with that asset. But the other part of that program is that the warranties exist. And
yes, I see.
The seller is warranting certain facts. And you obviously haven't been taken to the SPA in this case. But the particular warranty clause is in normal terms. It says you're warranting as at the date of the agreement in the normal way. And I would entirely accept in this particular case, this SPA, the warranties are what you might describe as quite strong. They're quite tough.
So you say the risk was allocated to the seller?
Well, the risk is allocated in way to both parties in such a way that I can't come along and say, I want to point to, I can't properly come along and point to a particular clause and say the risk is allocated here. If I was to say, well, the risk is clearly allocated to the buyer because we're buying it and we're taking it, I mean, that might be a submission I can make, but I couldn't make that submission without saying the warranties are there to do a job. And the point, the warranties doing the job is the very question we're dealing with. So that's the reason why I'm not promoting any allocation of risk arguments. But anyway, my learned friend says he doesn't like that part of the decision, but in my submission it's as a matter of principle in terms of the test, it's perfectly acceptable and indeed necessary. Now, in terms of the way in which this is decided on the facts, this is paragraphs 42 and onwards, and Mr. Justice Popple does that by reference to considering various different variables, and the variables are obviously the ones that are applicable on the facts and the evidence to that particular case. In paragraph 49 he says, and he's talking about the expert evidence, in short, Mr. Mines has still compared apples with pears despite his correction of total volume of business written. The AIG has simply not shown that the conventional prospective approach of assessment at the breach date offends the compensatory principle or results in a windfall to Aegeus. And then paragraph 50 and onwards, it deals specifically with the allocation of risk arguments in relation to that. And paragraph 52 is his final conclusion in relation to time on cover bad debt. So in terms of the test, for the purposes of this appeal, I'm going to try and assist in terms of what in an appropriate case means, which is what Mr. Justice Popple would have said. So I entirely accept and don't wish to argue against what Mr. Justice Popple has set in terms of his test, in terms of his two qualifications. I would wish to add, as a matter of submission, two glosses. The first one's very short and the second one's a bit longer. The first gloss is that the relevant contingency must be clearly identifiable, and that stops it being nebulous and vague. And the second gloss, which is longer, is that the contingency is directly relevant to the assessment of damages, is not one of a number of selectable variables from post-breach events.
Sorry, just so directly relevant to the assessment of damages.
The contingency is directly relevant to the assessment of damages, is not one of a number of selectable variables from post-breach events, and is the effective cause of a change in value of the asset being valued.
I'm sorry, I'll need that last bit again.
And is the effective cause of a change in value of the asset being valued. Now, my lord, my ladies, those glosses don't come from any authority, they're coming from the bar. And the reason they're coming from the bar in that way is because I'm trying to make sense of a world in which this Aegeus test does in fact have a chance of applying to an SPA breach of warranty case share valuation. But of course you may have a different conclusion, which is that it's just hopeless. But if we are not in the hopeless world, then that's what the answer is. So as far as this question of contractual damages is concerned, actual damage or reduction in value, no windfall. The aversion of catastrophe was because of my client's actions, and that's not a windfall in any view. And then all the events in 93 to 120 are a set of confounding variables, which mean that this isn't a proper contingency in any sense. So those are my submissions in relation to Appeal Ground 1. If I can turn on to Appeal Ground 2, quite a lot of this was left to looking at my learned friend's skeleton argument. I'll have to deal with a few things. But the primary point he pushed forward in his oral submissions was really an absence of reasoning. And my ladies, my lord, that's just completely a bad submission, because when you scratch below the surface of the judgment, whatever criticisms you may make, you see that the judge has tied his conclusions absolutely ruthlessly to the evidence. And I just want to make that good very, very quickly. If we can look at the supplemental bundle, please, tab 4. You will find Mr. Mesher's report. And please look at page 97. Just before we look at the question of the multiplier, which is the core thing, I'll just draw your attention to paragraph 4.9, which is Mr. Mesher's conclusion. Accordingly, it's unlikely that the market value of the company, as at the transaction date, is anything other than that which was actually paid. Come back to that point a bit later on. But paragraph 4.10 and onwards, he's reviewing the multiplier. And he has some comparables in the further paragraphs. And at the next page, on page 98, paragraph 4.18, he says the multiples above range between 3.81 and 4.53. The average of the multiples identified is 4.18. So that's where the judge is getting his material from Mr. Mesher's own report. And then if one goes through to paragraph 4.24, I therefore consider that the equity valuation of the company as at the transaction date was 3.3 million. This is not dissimilar to, albeit slightly less than, the price actually paid for the company of 3.5 million. Accepting that the market value to be the price paid, by my calculations, the resultant multiplier was in fact 4.34. This is not outside of a reasonable range and supports the contention that the price paid represented market value. And then Maloney Friend's already taken you to the joint statement, which is in tab 5. I'll just quickly traverse over that. In relation to, this is on page 112. Now, it's true that Mr. Mesher doesn't agree with, certainly here, with the level or the application of a multiplier. But it's important to note that in terms of the general principle, we say Mr. Mesher accepts Mr. Gates's point, just the point in the middle column, and I'll come to the actual oral evidence in a moment. But as a matter of principle, a reduction, a discount to the multiplier was something that was agreed between the experts, and I want to just put the final piece of the jigsaw in place, which and I know you have to take your life in your hands getting the transcript out, but I'll only do it for 3 minutes. Tab 16, page 338. So if you start on 337 right at the bottom, this is part of the cross-examination of Mr. Mesher towards the end of the trial on day 7. And the answer he gives at the bottom of page 112 over the top of page 113. Just to note this, he says, in my report what I do is try and approach the evaluation objectively, and I think I come up with a figure of 3.3 million, which is actually close enough to 3.5 million to support the overall value. And then...
I'm sorry, I can't find that. Where were you?
This is the bottom of 112. So if you're on page 337...
Yes.
And then the internal pagination, page 112.
Yeah.
It's the bottom answer.
Thank you.
But the passage you read out is just at the top of page 338.
Yes, yes, you're quite right. Sorry, my lady, yes, you're quite right. And then the rest of, I'll leave you to read these, but page 113, 114 and 115. To try and summarise what they say is that Mr. Mesher accepts there can be something which he describes as a qualitative discount, but he won't actually put a number on it, and the way in which he expresses himself in his evidence is that it's very difficult to say without knowing what the facts are, and that's, for example, page 115, lines 17 and 18. And then same thing on page 114, lines 13 to 17. He says, I certainly accept that there can be a qualitative adjustment. My position is that it's difficult to give an opinion on what level of qualitative discount should be without being aware of the facts.
I didn't understand. I think the judge picks up the word qualitative, doesn't it? I didn't quite understand what he meant by qualitative. It's just a discount, isn't it, to reflect?
Yes, but it is something which we say specifically referable to the multiplier, and that's what he says.
That's what you're trying to say.
But the point of this is that this is part of the jigsaw puzzle that the judge has to deal with. So what Mr. Mesher is saying is, I'm not going to put a number on it because I don't know the facts, and that's a very proper thing for him to say because he's the expert. He doesn't know, and you've got to remember this is during the trial where the misconduct's being denied uphill and down dale. So we don't have the findings yet as to how bad the misconduct is. And so Mr. Mesher is perfectly properly keeping the position, the powder dry. So the point really is that Mr. Mesher's saying if you know the facts, you can then come to a view as to what the qualitative discount is, and that's the exercise that not only the judge did, but was entitled to do.
Just as to the qualitative bit, what I've assumed is that he means an adjustment to take account of the quality of the asset, the reliability of the future income stream. You see what I mean?
Yes.
Because you've worked out maintainable earnings, but then there's a question mark, which you take into account because of the quality of what you're getting.
As your Lordship knows, the valuation of shares in private limited companies is a very difficult exercise. I mean, lawyers who are interested in precision sometimes at a loss as to exactly how it actually works, and we have all these different valuation methodologies. But the process of coming up with a multiplier on a EBITDA multiplier is often something that's often quite magical.
I mean, I think it must be very common for valuers to find various comparables, analyse and come up with different multiplier figures and different transactions, and then, as you say, somehow magically or as a matter of impression or plumping for a figure, they get to what they think the appropriate multiplier is.
Indeed, and I mean, obviously, my learned friend's submissions are to some degree, I would say, looking at this through the long end of the telescope. He wants to emphasise the fact that the small change in multiplier produces what seems to be a significant difference in the damages. And it's accepted that small changes in multipliers can make big differences to the end result. That's a given fact. It's something said in the Hutt Group. But the point is that's the wrong end of the telescope, because you need to undertake the exercise of deciding what the multiplier is. And it doesn't matter what any other multiplier might be. You need to decide what the multiplier for you is.
So my learned friend's about to move on. I was just invite you to read on to page 115 just to complete that part of the evidence.
Yeah, let's just read that.
Yes. I mean, here's a long answer there. 25% is the absolute maximum.
But the answer could be nil depending on the fact, so he's really handing it back to the judge, isn't he?
It is, and he has to do that because misconduct is being vigorously denied at this stage. All misconduct. So we come back to the judgment, and again, it doesn't need emphasising or labouring, but if we go back to paragraph 288, the judge's conclusion in relation to the top of page 158, partway through paragraph 288, he says the breaches in the present case were of a different order because they involve not only the running of a non-compliant operation, but the deceiving of the regulator in order to keep that operation afloat. And that's why this case is, as I said at the beginning, an egregious case. So this idea of no reasoning, it simply just doesn't add up. The judge has done exactly what you need to do in relation to these valuation exercises, which is to root himself firmly in the evidence, because the truth is the evidence is all you've got in relation to the difficult task of valuing shares in private limited companies. I'll quickly go through some of the other points that my learned friend makes before turning to other matters. I think in his written case he says reputational risk is no different from accounting errors. Well, that's just plainly wrong. Accounting errors are things that can be dealt with by the multiplicand. Reputational risks are something that affect the viability of the continued income stream. He also says in his written case there's no authority in relation to reducing the multiple in this particular way. Well, it is true, there is no example of a case in which the multiplier has been reduced, but it was something that was possible and asked for in the Hutt Group, but it was rejected on the facts in the Hutt Group case, paragraphs 159 to 173. But it's clearly something which is available in an appropriate case, and because of the egregious nature of this case, the double element of misconduct, this is a case in which I submit is entirely appropriate.
Using this method of valuation, if you are to take any account of reputational risk, it has to be in the multiplier, isn't it? I mean, it can't be in the multiplicand.
It has to be. It has to be. I mean, it's fair enough to unpack what you really mean by reputational risk, but we know with clarity what we're talking about in relation to this case, which is that there is a risk of all sorts of different things happening, but at one end of the scale there is a small risk of the business actually being shut down. And that's not a risk which can be discounted. My learned friend also says this is a growing industry, and that's why there should be no discount. My submission, there's no evidence of this. I don't know if he's pursuing that. But also it just doesn't deal with the question of valuation at the 14th of October 2015. And then in terms of the cost of cure cap, as I understand his written argument, what he's saying is he's not promoting an appeal based upon the cost of cure cap being something which the judge should have accepted. He's saying that should have be something which means there's no discount. Well, I think as my Lord Justice Newey said in argument, that just simply doesn't deal with reputational risk. So the final point in relation to the ground 2 of the appellant's appeal is this question of consistency and whether there's something unfair going on. And what I can submit is that there certainly isn't a rule in English procedural law whereby the moment somebody puts hindsight in front of the court or post-transaction events for some particular purpose, that just opens the floodgates to everything else. One has to look at A, the particular context in which this is occurring, and B, the relevant rules, procedural or substantive, which relate to that. And this isn't a source for the goose, source for the gander type of issue, because these things are completely different. No one was saying at trial that the post-transaction 2 years of costs were the costs that you were to effectively transplant to pre-transaction. They were simply saying that they are the best guide that we have, the best evidence you have available. And I mean, that is something which is entirely, in my submission, acceptable for the purposes of trying to work out what the suppressed costs are. Because one has to remember that the issue in this case was that profits were being inflated, and they were being inflated because costs were actually just not being incurred at all. And they were not being incurred because corners were being cut. And in particular in relation to the leachate plant, what was going wrong is that volumes that were being pumped through the tanks and through the leachate plant were way in excess of what was acceptable. That was causing all the breach readings. And the reality is there should have been a higher cost base. The truth is the leachate plant was taking much more than it should do. And that was happening in order to not only fulfil the contract with Newport City Council, but in order to maximise revenue illegitimately. So there were no costs to look at. There was no actual evidence in terms of what those costs were pre-transaction. So you have to reconstruct them. And also, one has to remember, in a case where misconduct is being denied very, very strongly throughout the course of the trial, what is the claimant to do? So that is effectively an evidential exercise where the judge is not saying these are the costs. He's just accepting that as a guide, as the best guide that's available. That's completely different from this question of whether, as a matter of law, this contingency, if you can call it that, is something you can bring in. That's a completely different test. It shouldn't be seen in the same question. So there's no unfairness. There's no there's no unfairness because if, as a matter of law, the appellants are entitled to have this contingency taken account of, then they're entitled to have that as a matter of law. And then in terms of the procedural aspects, the court's just taking the best evidence it can. There's no sort of unfairness in that.
So you say they are using the word qualitatively again, perhaps wrong in different context. But they're just two completely different things. One is a sort of best evidence proxy. One way of working out suppressed costs is by looking at what you did actually have to spend afterwards. So that's that. And then the other thing is a risk that you've got to put a figure on somehow.
Yeah.
We know how the judge did it.
Yeah, yes, my lady. And I'm, in terms of going back to the contingency argument, I'm not saying that we shouldn't examine this question at all, or certainly on the alternative basis. But the question is, I'm saying they just don't get anywhere because it's not really a real contingency. So I can't see how my learned friend can really sustain the submission that it is unfair to his clients. So, my lord, my ladies, that was what I wanted to say in relation to appeal ground 2. I want, if I may, now to turn to the cross appeal. And I've got two large headings to deal with here. The first one is my arguability question, which has been left for me by Lord Justice Newey, and the second one is the actual substantive argument, which can be dealt with fairly shortly. So in terms of this question of arguability, we've put in a comprehensive note with a lot of detail, which is in tab 19, and I hope your lordship and ladyships can see from that note that it's clear that tortious claims were before the court, and it's also clear that tortious quantum was before the court, and so there just simply isn't a new point. It's not. This is not something which is barred from being argued. But even leaving that note to one side, you can see that I'm right from just looking at the judgment. And I just want to take you through to 2 or 3 other parts which I haven't taken you to already. Paragraph 123 of the judgment. So this is on page 90, and it's a small point, but it's part of the clarification of exactly what's in issue in this case. Is in paragraph 123, the letter before claim is being set out, and as part of that, fraudulent misrepresentation, fraudulent misrepresented is set out around about 8 lines down on paragraph 123, and then if one goes over the page 3 lines down, we've also got mention of fraudulent misrepresentation is established. So this isn't something that's coming out of the blue, and then if one looks at 129, this is part of the expert evidence section. At the end of that, the judge says, although the experts noted the inclusion of claims for damages for misrepresentation, they did not consider that those claims raised any different questions or required separate treatment. And it's correct in a sense that the question of the tortious claims, they were definitely before the court, they were dealt with, and they were adjudicated upon. But they were, in a sense, less important in the claim. And the reason for that was because no additional loss was being claimed beyond the claims for breach of contract, damages for breach of contract. So, for example, there was no claim for consequential losses in this case. And the other thing, which is really the crux of the cross appeal, is that it was common ground between the experts and the parties that the warranty true value of the shares was the price paid. And there was obviously some bits around the edges that Mr. Mesher said, but I'll make that submission good in a moment. And so where you have a situation where that's common ground, just like it was in Aegeus, there's going to be no difference between the contractual and tortious measure of damages. And so this idea that somehow the tortious quantum claim or the tort claims themselves were not being promoted. I mean, what my learned friends say in their skeleton argument is that such claim wasn't before the court. It's just wrong. but I've already taken you through the parts of the judgment that deals with the misrepresentations. Just to quickly repeat the references, paragraphs 207 and 208. 209 deals with deceit and section 2.1. Then all the misrepresentations are dealt with at length, paragraphs 244 to 262. And then 273 are the attribution of the representations to the defendants. And then 277 to 278 and 279 deal with some of the judge's conclusions. So it's absolutely clear that the judge was dealing with the tortious claims and he was adjudicating upon them. And then I won't traverse over the note in tab 19 at great length, but you'll see that we've gone very carefully through the pleadings, through a disclosure statement, which of course is an agreed document, and then also I just want to show you the disclosure statement just very quickly. That's supplemental bundle, tab 10, page 211. So if you're on page 211, you'll see there's a heading causation, loss and damage. And the question, which is agreed for disclosure purposes, is insofar as the court determines the defendants are liable for breach of warranties and or misrepresentations, what, if any, recoverable loss did the declaimant suffer by reference to the individual alleged breaches pursued or at all? So we've got clearly that misrepresentation is right there in relation to loss. So I don't want to labour this. So the simple point is that the Singh and Das case is just simply irrelevant. We're not dealing with a new point. I'm quite surprised, I have to say, that this point is even being taken about the tort claims and the tort claims losses for tort claims. It is even being suggested that it wasn't before the court. And so I want to turn, if I may now, just to make my submissions on the cross appeal in relation to measure of damages in fraud, in tort. And if we could start, please, in the supplemental bundle, tab 4, page 97. I've shown you, actually, well, I could just show that again. Paragraph 4.9.
Sorry, I put the bundle away and I wasn't keeping up. So
sorry, I've actually shown it to you already, so it may not be necessary to get it out. But paragraph 4.9 of Mr. Mesher's report, which is on page 97, you've seen it already. It's the one where he says it's unlikely that the market value of the company as at 14th of October is anything other than that which was actually paid. And and then I've also shown your lordship, paragraph 139 and subparagraph 2 of that on page 97, which is recording of Mr. Mesher's views. The assumption that MDW paid the true value of GDE is therefore confirmed on a warranty true basis.
I'm sorry, that's 139.
Yeah.
Sorry, that's 139, forgive me, on
The
page
judgment.
97 of the judgment, yeah.
And it's 139
Sub 2, final sentence.
So 139.2. Sorry, was that the only reference, or was there another one as well?
No, that's it.
Yeah.
For the moment.
Yeah.
And the starting, and we'll come to the law now. The starting point for damages in fraud is the price paid, and there's nothing really controversial about this. This is what's set out in Smith New Court, which is in tab 6 of the authorities bundle, and I can perhaps just show you that very briefly. One turns into Smith New Court, tab 6. And at page 267. At the top of the page 267, part of Lord Brown-Wilkinson's speech, where Lord Brown-Wilkinson's setting out the principles. These are all extremely well known. The defendant is bound to make reparation for all the damage directly from the transaction. And then 3, in assessing such damage, the plaintiff is entitled to recover by damages full price paid by him, but he must give credit for any benefits which he has received as a result of the transaction. And then if one goes on to page 284, top of the page, we're in the speech of Lord Steyne now. So at the top it says it's right that the normal method of calculating the loss caused by the deceit is the price paid less the real value of the subject matter of the sale. And then down at D, there is in truth only one legal measure of assessing damages in action and deceit. The plaintiff is entitled to recover his damages a sum representing the financial loss flowing directly from his alteration of position under the inducement of the fraudulent representations of the defendant. And then...
Sorry, go on again.
No, go on.
Well, let me just ask this. You're entitled to recover his damages a sum representing the financial loss flowing directly from your alteration of position. Now here there are two possible alterations of position. One is you wouldn't have bought at all. On that basis, it makes perfect sense that you should get back all the money you paid, less the value of what you got. But the other possible alteration of position is you paid more than you would otherwise have paid. So supposing that you would have gone ahead but at a different price, is it still the case that you get back everything you've paid less the value of what you've got? Or do you get back the difference between what you would have paid and what you did pay? Yes. What you would have paid and what you actually got.
My lord, on that second analysis, you would get the lesser, you should get the lesser measure in terms of the pure alteration of your position. But this case is being put forward on the first basis.
On the basis you would not have bought. I think thought I understood you to say earlier on there was no finding to the effect that you would not have bought.
That's correct. I will check that in a moment. Excuse me, Lord, may I turn around?
Yes.
So, my lord, we'll have to produce. There's no finding in the judgment, and that may be the end of the way where I can take it. But I'll produce. There is a witness statement which was adduced at trial and cross-examined, in which that proposition was promoted, and that's a witness statement
Yes,
of Mr. Mark Hazel. Right?
Now, I suppose the judge didn't see it as necessary to make a finding on that because, so far as he was concerned, he was looking at the contractual measure.
My lord, that may be one explanation for it. Yes. But what I'll do overnight is we'll obviously have to see what the learned friends have said about it, but we will produce that witness statement so you can see that that's what the evidence was.
Yes.
My lord, if I can just go on just E, on 284E, in an action for deceit, the price paid less the valuation of the transaction date is simply that the method of measuring loss which will be satisfactorily solve many cases. So this is uncontroversial. So again, the price paid is the price that I mentioned at the beginning of my submissions, 3584224, and so that should be the starting point. And in terms of the objections to this, the objections are, in my submissions, very slight indeed. It said in my learned friend's written documents that that we should be foisted with the fact that we've overpaid, which is what the judge effectively concluded, because we wanted this asset for particular strategic purposes. So he's saying even though that you've substantiated your claim in fraud, you have to be stuck with what the judge has said, which is the lesser value, because you somehow wanted this asset for some strategic purposes of joining up your businesses. Well, that's simply not a reason. It's not an answer to this at all, because you're entitled to the price paid as the starting point.
We come back to the same point in a way. If the truth is you wouldn't have gone ahead, then on conventional tortious principles, you just get back your money less what you received. If, on the other hand, the truth is that you would have gone ahead at a lesser figure, then it may be that the lesser figure you would have paid would have taken account of the sorts of figures, the sorts of points that you're referring to.
Yes, and there could even be worlds in which those two measures of damages are the same.
They would be the same, wouldn't they? Because what you would have paid if you'd known the truth would have been the real value of the company.
But I mean, they are conceptually different measures, though, aren't they?
Would you necessarily have paid the real value of the company? I mean, if you had these particular reasons for getting this asset, you might still have overpaid.
Yes. But that may well be right. But just dealing with the allegation about wanting to overpay, that's not subject matter of any finding, or
No.
we don't accept that at all.
So the judge does say, though, doesn't he, somewhere that he thinks you did overpay? Isn't it part of
Yes,
his?
he does. So that's caused the problem, which is that
It's £500,000 extra, isn't there?
it's less than that, but it's on the warranty true value, despite the fact that it was common ground between the parties and the experts. The judge went off on a frolic of his own and decided the warranty true value was less than the price paid. Now, as a matter of contract, we have to just accept that. But the problem is, it's caused two problems. First one is that it doesn't give us our full measure of damages in fraud, in tort. And the second problem is that it means that he simply hasn't properly addressed the tortious measure of damages, which he needed to do. And that's what we're asking this court to correct.
But you were content, weren't you, that he should proceed on the basis of the expert's evidence, and in effect on the basis that there was one exercise that he was conducting?
Exactly. And that is the reason, or part of the reason, why we're being criticised here for somehow not promoting the tort claims, because in a situation where the price was the same as the warranty true value, we didn't need, it doesn't really add anything. The tortious claims don't add anything.
And you were not claiming any other compensatory elements.
Exactly. So the problem has arisen because the judge has done this exercise in relation to the warranty true value, which he's entitled to do in contract, although we don't like it, but he's not entitled to do in tort. So as far as the other objections that my learned friends put forward in their written documents, they're also saying that the cost of cure is a fairer basis for damages and fraud. I don't understand that point. I don't submit it doesn't have any substance to it. So that's the top figure. So subject to me producing Mark Hazel's witness statement and the court accepting it, subject to what my learned friends got to say, that's the top figure. And then in terms of the question of, come back to hypotheticals and hindsight in fraud, we've got some authorities to look at. And really there are two authorities, but the main one is the OMV Petrom and Glencore case, which is in the authorities bundle at tab 14. Now this is a decision of this court. It's a lead judgment given by Lord Justice Christopher Clark, with whom Lady Justice Black and Lord Justice Kitchen agree without further comment. It's a deceit claim only. It's about deceit in relation to bills of lading in respect of Romanian crude oil. And what the purchaser thought they were getting was so-called brand crude oil, but what it actually got was blend crude oil, something supposedly that it didn't want. And the argument being put forward at trial and in the Court of Appeal was that, notwithstanding the fact this was a deceit claim, because on a sort of comparative yield ex post facto analysis, the blends that actually were in fact provided was in fact oil which was as productive as the brands, then there in fact was no loss. And this argument was effectively dismissed very, very quickly by Mr. Justice Flo at first instance, and also by this court. And so if we turn up I'll pass over the head note, but if we turn up the judgment, paragraph 1, it's a claim in deceit, and paragraph 7 sets out where the deceit was. So we've got second line, Glencore created or caused to be created a suite of false documents which were designed to deceive and did deceive those in Romania who received and acted on them into thinking that the cargo in each case was either Iranian heavy or GOSM. And that's what the deceit was, and that was set out further. And then if we go through these to paragraph 31, this is a record of the of Glencore's submissions. And what they're saying is the discount is said to be wrong in principle. Its basis was that anyone buying one of the blends would want a substantial discount because the risks of using an untried blend in a refinery. Use of such a blend could reduce the output of refined product below what would be expected of the relevant brand or affect the machinery of the refinery itself. At worst, use of the blend might lead to a fire or more likely rust. But in the events which happened, nothing untoward occurred. In those circumstances, any discount is inappropriate, Glencore was saying. The measure of damages is the price paid less the benefit received being the real value of the goods. To make a deduction for risks which did not eventuate would be to attribute to the blends an unreal value and to compensate Raffirom and Petrom for a loss which it might have suffered but did not. Moreover, if the crude supplied had had some effect on the machinery of the refinery, Raffirom could have claimed against Glencore so that effectively Glencore was the guarantor of such risks. So that's what the submissions were. And then if one goes on, paragraph 37 deals with Smith Newcourt, and paragraph 38, Lord Justice Christopher Clark says, as is apparent from that summary, the basic measure of damages is the price paid less the benefits received as a result of the transaction, which will, in a case where property is acquired, be or include its value at the date of acquisition, which for present purposes was by agreement taken as the bill of lading date.
Just interrupting briefly, do we know whether here the purchasers would have gone ahead with the transaction at a different price or whether they would have declined to go ahead with the transaction?
Paragraph 11.
Yes, I see. Well, actually, even that's a bit ambiguous.
Well, probably, I think, is a finding. But
Yes.
But
They wouldn't have paid the price without being provided with further information and negotiating a discount.
yes,
Yeah.
that's the best we can do. And then, in terms of the actual decision in this case, that's really dealt with in paragraph 40, amongst other places. And at the end of that, Lord Justice Christopher Clark says, the fact, if such it be, that afterwards none of the risks to which the discount related materialised cannot alter the fact that the buyer was was induced to pay too much when he did so. And I rely on those words. And then if one turns on to paragraph 49, he says, in relation to some of Glencore's submissions, I do not regard it as appropriate to divide up matters in this way. The valuation is to be carried out as at the bill of lading date, being the date upon which Petrom's loss crystallised, and at which time any valuation would have to take account of the then risks. What happened after the bill of lading date does not affect the value of the blend on that date. A valuation without any discount would produce a figure which did not represent the market value at that date, at which time no one would have bought the blends without one. And then he deals with Aegeus, and has a section on horses as well. And he distinguishes Aegeus in paragraph 56. He says the Aegeus was he calls it the Aegeus. The Aegeus was a claim in respect of a non-deliberate breach of warranty which related to a future contingency where the debts would be paid, and not a case of a deceit which induced the purchase of an asset for a particular price at a particular date. And then he says in 57, in any event, Mr. Justice Popplewell's judgment makes clear that the approach to which he inclined could only be justified where it was necessary to give effect to the overriding compensatory principle. I do not regard Mr. Justice Flo's approach as inconsistent with that principle. That's in the current case. Whatever may be the position in relation to contractual claims not based on fraud, the duped buyer is entitled to compensation for the excessive price that he has paid, which is to be determined as at the date when he acquired the property. To require the deceiver to make such compensation is consistent with a policy of discouraging intentional wrongdoing. So this case in our submission is authority for the proposition that in relation to fraud, matters of hindsight or subsequent contingencies, including those which apparently go in favour of the defendant, the liable defendant, are to be left out of account because of the nature of the deceit claim.
So that's to do with the compensatory principle, but you've got an extra thing coming in here. There's a policy that lies behind that.
Exactly. And the other case I wanted to cover in relation to this is to make some submissions about McConnell and Wright.
I have a copy of McConnell and Wright. I don't know if my ladies do.
McConnell and Wright.
I'm using electronic.
Okay. Well, my lord, can I hand up some copies?
Please.
Do you- So, my lord, McConnell and Wright is dealt with, or is mentioned at least in Smith Newcourt, and it's mentioned in the company of Doyle and Albee, and also Clark and Urquhart, and it's mentioned on page 263 of the report for Smith Newcourt. I should be clear at the outset that I think there are some elements of McConnell and Wright that are no longer good law. And you know they're not good law because effectively they're lightly criticised in Clark and Urquhart, and then more strongly criticised in Doyle and Albee. And I'm going to provide copies of both those two cases to you to see that.
Please.
But the question is, what's still good law in McConnell and Wright? And in order to get to that question, I'm going to tell you what isn't good law in McConnell and Wright. So the two things that are not good law in McConnell and Wright is that there's insufficient account taken in this of the possibility of making a claim for consequential losses in deceit. And the second thing which isn't good law is really the very thing that's at the heart of Smith Newcourt, which is a criticism of McConnell and Wright about the rigidity of the date of assessment. So one of the core points of Smith Newcourt is that you can move the date of assessment in deceit where it's necessary to do so to achieve justice. So with those two caveats, and subject to the provision of those other cases, I just want to alert the court to some parts of the judgment which are, in our submission, still good law. And the reason I say they're good law is because if you take these parts that I'm going to show you of McConnell and Wright and put them together with OMV Petrol, you see that a case in 1903 and a case recently are both saying the same thing, which is that in relation to deceit, ex post facto hypothetical contingencies are not to be taken into account. Certainly not when they are supposedly favourable to the liable defendant. So I just want to take you to two passages. The first one is on page 557, which is part of the judgment of Lord Justice Roma. And just to be clear about the facts of this case, which I've only scanned briefly, but this is the case about a deceitful misrepresentation about a company owning some assets, and that was made good, but the company actually acquired the assets a matter of a few days later, and therefore the defence was, well, look, yes, there was a misrepresentation, but you haven't suffered any loss because, in fact, the company owns the assets that we said it owned, and that submission or that defence was rejected. So I'm not going to read it out, but if I could ask the court please to look at page 557. About halfway down the page, there's a sentence that says, therefore, if the £150,000 assets in fact did not exist, I don't know if your lordship's got that, your ladyships have got that, and read right through to the end, please, of Lord Justice Roma's judgment. sorry, the other passage I wanted to look at was in a previous judgment, the judgment of Lord Collins, Master of the Rolls, starting on page 553. And then almost in the centre of the page, there's a sentence saying, now as to that profit which Mr. Whittaker Wright claimed. Please could you read that all the way through to the third line of the next page. So, in terms of looking at those passages, in my submission it's very clear that it's a very strict test as at the date of allotment. There's no suggestion that subsequent events can come into the picture in relation to a claim in deceit. So, the combination of that case and OMV, Petron and Glencore means that this whole question of hindsight and contingencies is completely irrelevant to the claim for deceit. So if those submissions are made good, then the maximum I'm seeking is a sum of 625,548. And what my learned friends say, well, that's just absurdly large. But, my lord, my ladies, it's not in the context of a claim for deceit. Circumstances where, let's imagine we did a slightly overpay the company, but in deceit we're entitled to the damage that's directly flowing. And so the difference is between a situation where, let's imagine you've got a mug that's £5 and you pay £500 for that mug. Now you're obviously overpaying. Now in that situation, your behaviour is so unreasonable that it breaks the chain of causation between you and the person who's fraudulently induced you to buy the mug. Now if we've overpaid...
It does it? I mean, if the truth is that you've still been tricked into buying the mug, why aren't you entitled to be put back in the position you would have been in, you were in the first place, which was £500 in hand?
Well, your lordship may be right, but there has to come a point that you are so unreasonable. Must come a point where you're so unreasonable. I have to say, in practice, I've never ever seen, although I've seen the argument run, I've never ever seen it succeed. But there must come a point where your behaviour is so unreasonable that even your claim in deceit can't be made good. But the point is that if we've overpaid by however much the judge says we did, a couple of £100,000, we're still entitled to be compensated for that. Now, my lord, my ladies, I'm going to hand up, if I may, without further comment, just so you've got copies, Doyle and Ogilvy and Clark and Urquhart, because I'm very keen that, in terms of McConnell and Wright, we don't go astray. I'm not going to make submissions about them. My lord, may I turn my back, please, for a moment?
Yeah, certainly.
My lord, subject to this provision of Mr. Mark Hayes' witness statement, subject to my learned friend's remarks about that, I don't have any further submissions to make. So unless I can assist further, those are my submissions on the appeal and the cross appeal.
Thank you very much, Mr. Ayres. Mr. Sims.
My lords and ladies, in relation to the question of the response to the cross appeal, it won't surprise you to hear that precisely the issue which has arisen in the course of exchanges with my own friend, the concern we had as regards the cross appeal right from the get-go, as regards this court being invited in some way to carry out an assessment exercise itself. and that precisely highlights the problems which were identified in Singh and Das as to why the Court of Appeal should decline the acceptance, decline the invitation from my learned friend to even consider going there. But it's probably ultimately, obviously, a matter for you to decide. But I'm not entirely sure how I can conceivably properly respond to or put this court in a proper position to, in effect, substitute itself for the trial judge, which is, in effect, what my friend is inviting the court to do. And in my respectful submission, the point that has emerged as regards what the position would have been on the tortious measure, it precisely identifies why the point should simply be rejected ab initio, so to speak.
I mean, I suppose there are two possibilities. One, you say, well, the point wasn't sufficiently canvassed at first instance, C and DAS type considerations. The other is the point was adequately raised at first instance, but because the judge saw things in a particular way, he didn't make a finding of fact relevant to that way of putting the case. Now, supposing that were the position, then presumably this court wouldn't throw out the claim. It would say, if necessary, let's go back to the judge for him to make a finding one way or the other.
Well, that's exactly what I was going to say in terms of my sort of overview as regards to submissions. So I have three submissions to make. One is that the primary submission is the court should just simply say no, for the reasons which I'll expand on shortly. The second is to say, well, we're going to say this is incomplete business and send it back to the trial judge. The third possibility, which is I think what originally my learned friend was suggesting, which in my respectful submission is just simply hopeless, is that in effect this court is treated as a first instance court for the purposes of seeking to make findings about the matter. In my respectful submission, it would at minimum require to have to go back to the first instance judge and probably also require the parties to consider whether there's any further evidence to put in submissions to make on it, which rather takes me back to my first submission. But I just thought I'd flag that.
Yes.
The second point right at the outset is that so far as the position is concerned in relation to the authorities and the additional authority which you kindly drawn to our attention, it may just be helpful, as well as the authorities my own friend has helpfully handed up, just to look at how it's dealt with in Smith and Newcourt briefly, whilst we're on the point. It's slightly out of turn, but because I've just been looking at it briefly, it may be of assistance to deal with it now rather than tomorrow morning. So if we can look at the authorities bundle, briefly get this point up on the electronic version. I was looking at a few moments ago just to see if I can identify the passages efficiently. Smith and Newcourt is behind tab 6 and it's at page 61. And the first reference we see to McConnell in it is at page 261 in Lord Brown Wilkins' speech at D through to G. So there's a reference to some 19th century case law which culminated in McConnell and Wright.
So that's the date of assessment point.
Yeah. And it would then, we then get the subsequent passage and reference to it. Again, I think the Clark and Urquhart point that I think my learned defendant's just drawn to our attention by reference to that case, but it's actually captured within the speech of Lord Brown Wilkinson at page 263. C. And then there's the question of, in short, the speech seems to indicate, you see it F, the decision which restated the law correctly is drawn in Norvill, and then we then have...
just going back to what Lord Atkins says in Clark and Urquhart, and it may be that when everyone's had a chance to look at the authorities more fully, it'll become clear.
Yes.
Lord Atkins says the formula in McConnell and Wright may be correct or it may be expressed in too rigid terms. So what is his concern there?
So he leaves the point open, I suppose, there as to whether or not actually it's correct, as to it being too rigid and too inflexible. And in our respectful submission, this all really comes back to the point that I was seeking to beat the drum with this morning, which was that actually one needs to come back to the overriding compensatory principle and not view these general measures or general points as being inflexible, rigid formulae within discrete little pockets, but instead the court seeking to ascertain the correct manifestation of the compensatory principle within them. And you then, I think, get probably what amounts to a disapproval sort of brief passage at 266 C. So there's a review of cases up to then, including cases like county personnel and pool, which we haven't taken into because in the authorities bundle, which re-emphasises the point about not being too rigid in how one approaches things.
Is this about date or is it about other things?
Well, I think it's in my respect for submission, it's a general point, which is that you can have a number of different types of relaxation from the normal approach, can't you? One is to move the date, and the other is to allow in hindsight to assess differently values put on things at the time, which, when you take into account the benefit of hindsight, could be assessed more accurately on a different basis.
Yeah.
And in my respect for submission, that applies to contingencies, but it's not restricted to contingencies. And simply because Smith and Newport was a case where the court decided to change the date, it doesn't mean that the lesser approach of not changing the date, but just taking into account hindsight in order to assess a value is any less proper or appropriate, having regard to the overriding compensatory principle. So in the limited time available, that's I think where we respectfully submit we get to in terms of that approach, which is to steer away from treating these cases as applying rigid formulae. Yeah. But if we have any further overnight thoughts in that respect, then we'll add to those submissions, hopefully without repeating them. So insofar as the overview observations we would seek to make in relation to the cross appeal, there are three overview observations or submissions I want to make right at the outset so far as Melanie and Friends submissions are concerned, which is that yes, it's right that for the purposes of fraud, there is a certain relaxation on certain aspects of how the courts apply the tests in relation to, for example, foreseeability in particular being one of them. But nevertheless, even in the context of allegations of dishonesty, it's still a compensatory measure. And that is, of course, subject to certain very limited exceptions, which are claims for aggravated or exemplary damages. English law does not recognise the notion of awarding additional damages simply because of a finding of deliberate wrongdoing or fraud. And if we need a reminder of that, I think I probably already briefly gave you the citation for this this morning, but it's dealt with by Lord Reid in one step at paragraph 25. And it may just be worth briefly looking that up as the most recent authoritative statement from the Supreme Court on damages generally. So it's page 669 of the report, and there's a discussion about tort. In the first sentence, in tort, although damages may in circumstances be awarded for punitive purposes, the general principle is that damages are compensatory. It's reference to Livingston and Royals and subsequent case law, considering obviously the slightly different point which was before the court, which was to do with awarding damages for user, route and park damages, negotiating damages. In addition, one gets that also from the speech of Lord Steen in Smith and Newcourt, and I think my learned friend briefly touched on that in his submissions, but just to go back to the particular passage so you have it in mind for present purposes, it's at 284D2E, so Smith and Newcourt is behind tab 6, and it's internal pagination 284D2E. We've in fact both got markings up on this particular passage.
Mm-hmm.
But you see the restatement of the position so far as the legal measure of assessing damages in action for deceit is concerned, which is the plaintiff is entitled to recover as damages a sum representing a financial loss flowing directly from his alteration position under the inducement of fraudulent representations of the defendants. And then there's reference to the analogy of the assessment of damages in a contractual claim. Springs to mind and the observation of Lord Mustill that there are not two alternative measures of damages at opposite poles, but only one, namely loss truly suffered by the promisee, and then sets out the normal measure, but emphasising that it's not a substitute for the single legal measure. And of course, you already have the brief submissions I made a few moments ago about the difficulty in carrying out such an assessment now on this appeal, but this is just a general point that as a starting point, in our respectful submission, my learned friend is wrong to seek to make the distinction between fraud and contract so far as that basic principle is concerned. The second point we would seek to make is that a decision not to disapply general rules due to a case being an intentional tort operates within certain defined parameters which do not apply here because the approach taken in the first instance court already departed from the general rule to the benefit of the claimant. So already in this case there was a detailed examination of 2 years' worth of conduct before and after purchase. For two reasons. One was in order to make good their breach of warranty and misrepresentation allegations. The second was in order to show a loss figure. And I repeat the submissions I made earlier on about the concerns we had about that exercise, that the figure which even Mr. Mesher came up with, could it really have been said that that was a product of a fair figure, independent of the way they carried out their business activities? Our concern was that that, in any event, overcompensated them. But ultimately, it was the approach that the judge took. And we repeat that it's not a principal distinction to say, well, we're using it for a different purpose here, simply because we're using the after the event evidence to provide an assessment of the costs up to the date of purchase. You're still using after the event facts in order to assist with the assessment exercise. And it's not a principal distinction to say, well, that's different from the assessment exercise we're carrying out in relation to reduction of the multiplier. It's not a satisfactory principal distinction. It's not a satisfactory distinction of the facts. So far as the question of the case law that my learned friend relies on, if you look at cases such as OMV, which he heavily relies on in support of this case, there wasn't that factual inquiry. The Court of Appeal in OMV noted in clear terms that one couldn't say whether or not there might have been problems caused by the use of this blend crude. They simply just didn't go there. That's to be contrasted with this case, where not only did we go there, we went there in Technicolor with a forensic examination, which my learned friend fairly accepts now before this court, showed that the risks had not eventuated.
No, we're just coming up to time, but could we just go back to OMV to see what they did say about the risks?
So if we look at OMV, it's behind tab 14.
Yep.
And obviously we have the point which I think my learned friend has already drawn to your attention about the finding that they probably wouldn't have got ahead with this contract, or in any event would have looked to a negotiated discount. But then if we look further on in terms of the points of principle which have been marked up, really the relevant passage, I think, starts with a criticism of the assessment by Glenn and the rejection of that by the court. And a number of reasons are identified. And then we then have the conclusion at the end, paragraph 49, the court rejects the notion of being as appropriate to divide up matters in the way suggested. And they make the point which my learned friend seeks to emphasise, that what happened after the bill of lading doesn't affect the value of the blend on that date. And we then have the discussion about horses from paragraph 55 onwards, and in particular the discussion about Aegeus. And we then have the point that so far as fraud is concerned, in the case of fraud, the answer is generally the date of purchase at paragraph 61. And then we have consideration of Bacciatini at paragraph 63. And the submissions based on Bacciatini that there isn't this inflexible rule so far as taking the date of breach, or indeed restricting one to events before then, is rejected in paragraph 65 on the basis that it wasn't a fraud case, the facts were completely different, and it didn't involve any sale. In the present case, the defect in the cargoes was unknown until 20 years later. There was nothing that Petron could have done about it in the time, nor could it be said that the cost of taking any step was the measure of Petron's loss. Well, all very different from this case. This case was assessed by looking at the cost of taking steps by the successor business. Here, the defect was known within a matter of weeks. Here, the loss was assessed on the assumption and by reference to the fact that the trading activity and pattern before and after were all materially the same. Now, my learned friend drew your attention to certain events after the event to suggest, well, look here, there were certain periods where there were shutdowns in order to try and resolve the problems in relation to the plant. That happened in the period both before and after, because there were difficulties in terms of operating the plant during both periods. So the fact that there were periods when the equipment needed to be stopped and restarted is of itself not unsurprising. You have the evidence before the court that the custom was not lost during that period, and that there's no evidence of any adverse effects in relation to the regulator during that period. So the future potential risk to the wider business associated with a reputational damage reduction just simply didn't materialise, as known by the judge and by the parties on the basis of the forensic inquiry which had been conducted by the claimant because of the way they put the case. And it's the factual and evidential basis for that inquiry which puts the court in the picture, which is not there in OMV and these other cases where the court says, well, I'm not going to even look at that. You are a person who's committed a fraud. I'm not even going to allow you to examine that question.
And is that going to be a convenient moment?
I think it probably is.
In which case, 10:30 in the morning.